I wanted to make a short video about the CCIA, or the Concealed Carry Improvement Act, because there's a lot of information about the CCIA in New York out there. Not all of it is correct. A lot of it is evolving. And so I wanted to take a moment to sort of let everyone know where we started, where we are right now, and where I think this is going to go in the future. So firstly, the Concealed Carry Improvement Act, or the CCIA, and I just hate calling it that, because the purpose was not to improve concealed carry. The purpose was to make it as difficult as possible for people with gun licenses to go ahead and carry their firearms. And the hope was that if they made it as difficult as possible for people, that they would just leave their guns at home, and New York could accomplish their goal of keeping all of its citizens disarmed. So there are various different aspects to the Concealed Carry Improvement Act. We can put them in essentially three different categories. There's the aspect of the Concealed Carry Improvement Act that made it more difficult to get the gun license in the first place. There is the aspect of the Concealed Carry Improvement Act that created this whole new category of felonies for carrying guns at what they call sensitive locations. And then there was a new category of felony created for people who were caught carrying guns at what they called restricted locations. First of all, about the licensing. Essentially, after the Bruen decision told New York they have to give pretty much everyone a gun license, New York was looking for ways to make it as difficult as possible for those people to get gun licenses. So first of all, they imposed an 18-hour training requirement. This 18-hour concealed carry class is essentially 16 hours of classroom instruction, 2 hours of shooting instruction at the range, and is designed in large part, in my opinion, to just make it as difficult as possible. New York didn't say what the curriculum was. They came up with the fact that they were going to require 18 hours and then created the curriculum after. In addition to the 18-hour class, New York also started requiring 4 reference letters, 4 references that had to be filed along with any application for a concealed carry license. And in addition to that, New York required that you turn over your social media accounts so that the licensing officer could review them before you were allowed to get a concealed carry license. Now that provision, the social media accounts, has since been found unconstitutional. The rest of the licensing issues still under review. There's a lot of litigation still going on, and it's very likely that this 18-hour class and these requirement for 4 references is going to end up before the U.S. Supreme Court. The other aspect of the Concealed Carry Improvement Act that we have to discuss, and is probably maybe the most difficult part of the Concealed Carry Improvement Act for the average concealed carrier, is the number of sensitive locations. New York wanted to make it so that there were very few places you can carry a gun. So they created these 2 categories, restricted locations and sensitive locations. Sensitive locations are things like government office buildings, post offices, courthouses, treatment centers, schools, nurseries, daycares, public parks, zoos, aquariums, buses, bus terminals, theaters, concert halls, banquet halls, subways, trains. The list goes on and on. And there's been a lot of litigation about the various aspects of this. There's been a lot of back and forth. Quite frankly, a couple of federal district court judges in northern and western New York have ruled that many of these sensitive locations are unconstitutional. The appellate court, the Second Circuit Court of Appeals, has reversed those judges and basically said, no, New York can enforce them. Likely, this is going to get to the Supreme Court. For now, most of the sensitive locations are still in effect and are enforceable. Quick interruption, my name is Peter Tilem. I am New York's Second Amendment attorney. We set up New York Tac Defense, which is a prepaid legal plan for gun owners. You should go to the website, www.nytacdefense.com, and check it out. Now back to the video. Now, the next category of places where you can't carry a gun are what they call restricted locations. Restricted locations are any place open to the public, such as a supermarket, a shopping mall, a department store, any kind of store that is open to the public, a bank. And what the law said was that if there's a place that's open to the public, then you are not allowed to carry a gun at that location unless there is a sign posted that demonstrates that the place is open for concealed carriers, meaning that people are authorized to carry guns. There has to be a sign posted affirmatively giving people permission to carry guns. The thought was that no company, no business was going to do that, and so the average person would not be allowed to carry a gun in any of these restricted locations. That has been found to be unconstitutional by the district court judges, and in fact, that has been upheld in the Second Circuit Court of Appeals. So therefore, although this may go up to the Supreme Court also if New York decides to appeal, for right now, that restricted location requirement is still stayed, meaning that New York can't enforce it, and you can carry guns in these restricted locations. Or essentially in any place open to the public, unless there's a sign that affirmatively says you can carry a gun at that location. Where are we going from here? I think the import of the Bruen decision was not necessarily only that you have a constitutional right to carry a gun outside the home. The import of the Bruen decision is that gun control laws, according to the Supreme Court, are inherently, presumptively unconstitutional, and that the burden is on the government to show that in the history and tradition of the Second Amendment, there was an understanding dating back to 1791 and the time of the passage or the ratification of the 14th Amendment as well, that there was an understanding that the Second Amendment didn't cover this behavior. I think it's very unlikely that when the Supreme Court does their analysis, they're going to find that it's constitutional required someone to do an 18-hour class before they apply for a concealed carry license. I think it's very unlikely that the Supreme Court is going to say, okay, you can't carry a gun in a public park because in 1791 that was the understanding of the Second Amendment. There's a lot of litigation that still has to go on until we get a final answer on this. And this is very much in flux, which leaves New York gun owners in a difficult position. Where can you carry a gun, and where do you get the information about where you can carry a gun? Well, we're New York Second Amendment attorneys. We're here to help. But it's very important that when you leave that house with your gun, you have the latest information available on where you can carry that gun and where you can't carry that gun.